Thank you everyone for joining us today. Welcome to a new session with Rights and Responsibilities Awareness Initiative. Today we have Professor Stanley Michael Lynk, one of the leading legal experts in Canada. He will present us today about the Human Rights Code of Ontario. Michael Lynk, we are delighted to have you here today. Thank you very much for joining us. And sir, the floor is yours.
Thank you very much for that introduction, Haitham. Thank you very much to Rights and Responsibilities for inviting me to speak. It's always a pleasure. This is a great program of spreading community awareness about legal rights in our society and legal responsibilities in our society as well. I'm a law professor at the Faculty of Law at the University of Western Ontario, here in London, Ontario. I teach in a range of areas, but I've taught a number of times the law school's course on human rights law in Canada. Just one second. And it's always one of my most enjoyable courses to teach and one of my most enjoyable areas to want to speak about because the law is a cornerstone of the modern Canadian legal system and our legal society. If a country has a strong human rights legislation, which it faithfully implements, then human rights, the spirit of human rights and the values of human rights wind up getting inculcated throughout the society. And we become that much more trusting, that much more tolerating, that much more accommodating, just a much more liberal and welcoming society. What I plan to do tonight is to speak for about 20 minutes to give you a brief overview of how our human rights system works in Ontario. And then I'm happy to have the floor open right till 8 o'clock tonight to answer any of your questions. I would ask you when you ask questions to try to make them concise and short and ask them in a way that's going to also appeal to other people as well. I mean, you may have specific issues, but I think in the fact we only have an hour tonight, it'd be good when you ask questions to be focused on what kind of question you want to have answered by me. So I'm going to try to speak very briefly about 5 aspects of human rights.
If I may just to interrupt you, Michael, before we start. If you have any questions, please feel free to post them into the chat so we can answer them. So yeah.
Okay, thanks for that. You had mentioned that to me before.
Yes,
so the first of the 5 things I wish to talk about is about the Human Rights Code itself. This is a statute that's been in Ontario, in the Ontario laws since 1962, for almost 60 years now. And it winds up having 2 central features to it that I want to explain to you. First of all, what it does is lays out, I guess, the grounds that are protected in Canadian law. And that includes a number of important areas. It would include disability rights. It would include rights to be free of discrimination on the basis of race, of religion, of being an ethnic minority. Family status is an important right. Age is an important right that it winds up protecting. There are a total of about 15 rights altogether that are protected by the Human Rights Code, and each of them are to be interpreted in a very broad and liberal fashion. The way in which the courts have told us to think about these rights is that human rights are to be interpreted broadly, and exceptions to human rights are to be interpreted narrowly. As well, the Human Rights Code lays out a number of areas which are protected. So we think of the social areas where human rights discrimination can arise. It can arise in seeking rental housing, i.e. accommodation. It can arise in employment. It could arise in contracts. It can arise in retail services when you're going into a store or a restaurant to seek services. Most of the complaints, human rights complaints in Ontario and right across the country, arise out of employment. Somewhere between 75 to about 85 complaints that are filed with in Ontario each year with the Human Rights Tribunal are alleging discrimination on the basis of employment. Now, it can happen in other areas as well, such as services. I think probably the second most common area where human rights complaints arise is in educational services, including obviously in schools and universities. It can also occur in trying to rent a house. Those are probably the three most common areas where complaints wind up arising. With respect to the various grounds of complaint, I don't know if you've ever thought of what would be the most common area, but whenever I ask that to my class of law students, they get, well, is it gender? Is it race? Is it sexual orientation? Is it religion? Well, actually, it's none of those. The most common area, the most common ground of complaint with respect to discrimination, year after year, in every single jurisdiction across the country, is disability. And so when you put those, the area where complaints most often arise, a social area of activity, i.e. employment, and the most common ground of discrimination, disability, then putting those two together, the most common range of complaints going to human rights tribunals are a complaint that I've been discriminated against in the course of my employment because of my disability. And I'm happy to talk about that in a few minutes in a little more detail. But that gives you an idea of where what the grounds are, where the social areas of activity are that wind up being covered. So the second point I want to be able to raise with you is where is a complaint filed and what happens to it when it's filed? Well, in Ontario, we have two distinct bodies. One is the Ontario Human Rights Commission, and the other is the Ontario Human Rights Tribunal. The Human Rights Commission is largely an educative body. It has, it winds up educating the public on the rights and responsibilities with respect to human rights. It does education sessions and training sessions for companies in particular, for school boards, for a range of institutions, and explains to them what is the modern thinking about human rights and how to make sure that your operations comply with human rights. The Ontario Human Rights Commission also tries to raise issues of statutory reform to the Ontario legislature, where they try to persuade the party in power to pass legislation that will wind up improving and expanding the scope of the Human Rights Code. The second body is the Human Rights Tribunal. That is we lawyers would say, a quasi-judicial body. It winds up having chairs. It winds up receiving complaints under the Act. And if it thinks a complaint is warranted, at least to get as far as a hearing, it will then conduct a legal hearing with both the defendant and the complainant, presenting evidence, making arguments, putting their best case forward. And the tribunal will then go away, think about it, weigh the evidence, weigh the law, and then issue a decision which is binding on the parties. In all of this, the Human Rights Tribunal has to act procedurally correctly. A person can represent themselves. There is something called the Human Rights Legal Support Center, which winds up giving advice and may even sometimes representing individual claimants if they think their case is good and they are not able to afford hiring a lawyer or a representative to present for them at a hearing. I should say there are a number of occasions when somebody files a complaint, goes to the Human Rights Tribunal, and argues the case themselves. And that's always a very difficult issue. You're allowed to represent yourself if you wish, but if you're facing a lawyer on the other side, and there are lawyers who sit on the panel as as tribunal adjudicators, then without a lawyer or a skilled representative, you're at a great disadvantage in trying to present your own case on these matters. And I can answer questions from you if you wish a little bit later on with regards to that. So, but keep in mind these two different bodies. The Human Rights Commission does broad education and training with respect to human rights in Canada. But if you're going to file a complaint, you think that you have been discriminated against on any of the protected grounds listed in the Human Rights Code because of something that happened at your place of work, something's happened to you or your child at your place of education, you've been discriminated against with respect to entering a restaurant or when trying to shop at a shopping mall, or in a contract you signed with somebody else, or in trying to rent a place, then what you do is then take the application form that's on the website of the Ontario Human Rights Tribunal, you fill it out, you file it, and then at some point you're going to be contacted by the tribunal, by somebody who works for them, to try to process your complaint. And before you reach a tribunal, there is a mediation process. So what they will do is have a human rights mediator who will mediate between you, and let's say it's something that happened at your employment. You think you were discriminated against or even fired on the grounds of a prohibited ground of discrimination, your disability, your race, your religion, your age, your gender. Then what you can do is go through this mediation process, and if you think that the offer of settling the case is fair, you'll take it. If you don't think it's fair, then you take your chances of going on to the tribunal to have a hearing on that matter. So those are the second and third things that I wanted to raise with you, the understanding what the Human Rights Tribunal does and understanding what the Human Rights Commission does. If somebody wins their case in front of the Human Rights Tribunal, what kinds of remedies does the Human Rights Tribunal wind up awarding? Well, if you were, for example, were fired from work and your firing was based in whole or in part on a prohibited ground of discrimination. Let's say you had a disability and your employer fired you because you couldn't do everything that your job description requires you to do. But the employer didn't make any attempt to try to accommodate you at work. And you take your case to the tribunal, you present your case, the employer presents its case, and you wind up winning. What kinds of things can the Human Rights Tribunal wind up awarding to you? Well, it can award back wages for the time from when you're fired to the time of the award. It can award benefits that you were lost out as well. Suppose your workplace, you had a health plan which paid in part for, say, your vision, for your eyes, your eyeglasses, or for your dental care, or they had a drug plan. They can pay for whatever you would have lost during that period of time. If you've been off of work for 10 months between the time of firing and the time when you receive your Human Rights Award, then you may be eligible to be awarded your some or all of your back pay. If you wish, you can ask for the remedy of also being reinstated back to the workplace where you go. That's rather uncommon for people to want to do that. If they've been fired and they think they've been discriminated against, most of them want to be able to have their day in court to prove that their employer had discriminated against them and to receive damages for that. But most of them don't want to go back to work at that place where there's already a sour relationship with your employer. But in addition to awarding back wages and lost benefits, one of the biggest parts of the awards is for the Human Rights Tribunal is able to award human rights damages. Now, it all depends upon how particularly awful or egregious the conduct of the defendant was. And again, I'm going to use the example of an employer. But if the employer had shown no interest in wanting to try to accommodate your particular disability, your bad back, or your heart condition, or your depression, or your addiction, and didn't offer any kind of work adjustments to accommodate you, in addition to getting back wages and back benefits, they may award anywhere from $1 to $5 to $20 to $35 to $50,000 in damages. Obviously, awards of $50,000 are quite rare. There really has to be an exceptionally egregious conduct or misconduct by the defendant, by, in this case, the example I'm using, the employer, to get an award that high. Generally, damage awards for human rights damages are in the range of perhaps $5,000 to about $20,000 commonly. So those are the sort of things that human rights tribunals can wind up doing. They usually don't award legal costs if you have to hire a lawyer. And that can be painful because if you do win your case, you may find that a significant part of the damages you did win are going to be absorbed by your legal costs if you don't get a lawyer for free or for a low price through the Human Rights Legal Support Center. So those are always things to keep in mind. And I should tell you as well, if you ever did have a human rights issue that arose and you wanted to complain about it, I've emphasized the route going to a human rights tribunal. There is a route as well that goes to the courts, but that is much more complicated. And generally, if you want to go to the courts, you've got to have probably a separate action that you're filing, that you were wrongfully dismissed, and you're throwing in a claim for human rights damages in order to be able to go in the courts. For most people, it's much more accessible to be able to go to complain to a human rights tribunal and to have your case heard there, as opposed to going in the courts. Courts generally are much more formal. You really do need a lawyer when you go, if you're going to be represented in the courts, because of the very complicated procedures and the rules on evidence. And essentially the only people I see who go to the courts with a human rights complaint are those who generally have fairly high salary jobs where they've been dismissed or let go, where they think at least part of the reason for losing their job is based on a prohibited ground of discrimination forbidden by the Human Rights Code. For most ordinary people, your best bet is to go in front of a human rights tribunal where they actually are expert and skilled at handling human rights cases. So the fifth and final area I want to speak to, which is going to take me a few minutes before I turn it and leave it open for questions, is what are the different important grounds of discrimination that people complain about? I've rhymed off earlier on in my presentation what the ordinary grounds are. As I said, the leading ground of complaint is a complaint based on disability. And the reason why disability is year after year named in somewhere between 30 to 50% of all complaints going to the Human Rights Tribunal in Ontario is because there is such a variety of ways of having to accommodate somebody, because there's such a range of disabilities. My bipolar condition needs a different kind of accommodation, say in the workplace, than my bad back or my heart condition or by my bad knee or the addiction I have to painkillers or any sort of range of areas which are commonly thought to be disabilities. I should tell you that what is a disability is a fairly wide definition. I've seen cases which say that someone can have an addiction to a range of things, including gambling, including tobacco. Basically, human rights lawyers follow what physicians say, and if doctors, and more specifically psychiatrists, have stated that that someone can be addicted to alcohol, yes, but addicted, say, to tobacco as well, there may be cases where somebody is discriminated against because of their particular addiction to tobacco. That would amount to the ability to be able to file a complaint under the Human Rights Code to the Human Rights Tribunal. Employers often wind up fumbling the issue when it comes to properly accommodating somebody with a disability. Many employers don't realize that the Human Rights Code applies to them. Many employers don't realize that even if they do know the Human Rights Code applies to them, that they have a pretty broad responsibility to provide an accommodation up to the point of undue hardship for an employee in a particular workplace. If you have specific questions regarding this, I'm happy to answer them. But let me give you one example of how this winds up working. And this is drawn from a real case that I'm familiar with. A nurse working in a hospital on an ordinary ward develops a bad back. And that's often a very common issue, a health issue that rises with nurses because they do a lot of bending and a lot of lifting. She was off work for a number of months. And when she was ready to come back to work, her doctor said she can come back to work, but she can't do any heavy or even light lifting. So if you assume that somebody, that a nurse on a ward, let's say 70% of their job duties are light duties and 30% of their job duties are heavy duties. This nurse is going to come back to work, but her doctor's note says she can only do 100% light duties. So the employer is required to accommodate her up to the point of undue hardship, which is a pretty onerous responsibility on an employer. So it brings the nurse back, it rearranges all the duties, such as this nurse has a 100% light duty job and is paid her full wages for that, which means that all the other nurses on her shift now, instead of having 70% light duties and 30% heavy duties, the ratio now shifts to 67% light duties and 33% heavy duties. They have a slightly heavier load to carry, and that's accepted by the law. Well, let's say a second nurse on that same shift winds up developing a bad back, is off work, is ready to come back to work, but again, her doctor says, or his doctor as it may be, my patient can only do 100% light duties. And so the hospital finds a light duty job for her on her regular shift, which means the load becomes slightly heavier for the remaining nurses. They're now doing 64% light duties and 36% heavy duties. And at some point, that's got to stop. At some point, it becomes too dangerous for the remaining nurses to assume a greater and greater burden of heavy duties. But that gives you an idea of the kinds of steps that, for example, an employer would have to do in order to try to accommodate somebody. The employer cannot say today, well, you can't do 100% of your job duties, therefore I haven't got a position for you because you're bad back. The employer must turn the workplace upside down trying to see if it's possible to accommodate that person by rearranging some of their duties, giving some of their duties to other people to perform, and giving perhaps more light duties to that particular person. The range and responsibility of what an employer has to do, large or small, to ensure that employees are not disadvantaged by their disability, their age, their race, or whatever other area is covered by this, is quite extensive. So that's disability. Let me just mention a couple of other areas. Religion is a relatively common area of complaint. Again, I'm most familiar with cases that are rising in the workplace, but employers, are now beginning to realize that they have to accommodate on the basis of religion. And that might mean, for someone who, for example, is a Muslim, is a devout Muslim, and wishes to go to Friday prayers at the mosque with a Monday to Friday regular work week, that the employer may have to give them a little bit extra time on a Friday in order to be able to accomplish their religious duty of going to the mosque on a Friday at noon, and then find another way of that person making up the time on another day or working later. Or I know at the university, we now try to accommodate students of all religions by creating particular prayer rooms for them, where they can come and peacefully pray, for example. The university is big enough operation that they can find rooms all around the campus to ensure that students have these rooms for themselves to accommodate their religious beliefs. Same thing is true with respect to grade schools as well. that there has to be accommodations on the basis of a child's disability or a child's religion as well. The one area I just want to speak briefly about, which is a relatively new and developing area of human rights, which may affect or interest some of you before I then open it up for questions, is family status. The term family status has been in human rights codes for a long time, including in Ontario. But for a long time, there was such a narrow understanding in the law of what family status meant that there was virtually no movement or no development on that particular area. But now, in the last 15 years or so, the law has moved really quite rapidly on family status, to the point where it's becoming, the third or fourth most common area of human rights complaints. Let me give you an example with respect to this. This is a real case. There was a husband and wife who worked together for the Canada Border Security Agency as working at Pearson Airport in Toronto. And they'd be the people who would screen visitors coming from international flights to ensure that either they were properly returning Canadians, or if they were visiting from abroad with another passport, they had the right to be able to enter Canada. So this couple, they worked rotating shifts, and the rule at the airport was you have to work, say, 2 weeks do the early morning shift, 2 weeks do the late morning afternoon shift, and then 2 weeks doing the late afternoon evening shift. And we don't have room to be able to keep you on a consistent shift. So the wife had a child, and then several years later had a second child. And she found there was a burden for both of them to try to find daycare that would look after their two young children. They didn't have family in Toronto, and still maintain these rotating shifts, because they were on opposite shifts to try to accommodate them, but still meant there were lots of holes in the schedule where neither of them could wind up providing care for their two young kids. And they had tried to find evening daycares that were open. It wasn't possible. They tried to find babysitters to come in. That wasn't always very reliable. If someone didn't show up for a babysitting assignment with them, it meant they lost the shift, and they had to phone in on an emergency. I can't come in tonight. So she asked, can I please work on a straight day shift until my kids are somewhat older? And the Canada Border Security Agency said, no, everybody, yes, you can, but if you're going to do that, we're going to move you from a full-time responsibility to a part-time status, which meant that she not only lost a huge number of hours of work each week, which affected the family income, but when you move from a full-time status to a part-time status, there was a significant loss of benefits. The benefits provided for full-time employees was a much richer plan than for the part-time employees. So she said, yes, but I'm going to complain. And she wound up complaining, and this went up and down through the tribunals and the courts for 8 different decisions. But the happy news is, at the end of the day, she won a big case in 2014 called Johnstone and Canada, where what the Canadian Human Rights Tribunal said was, you employer, you Canada Border Security Agency, you haven't shown us that it would cause you undue hardship. That's the test, that you haven't shown undue hardship by accommodating Ms. Johnstone by working a straight day shift during the time when daycare issues were a significant responsibility for her. So that was a big breakthrough case in Canada. And now there are a lot of cases where employees, particularly those with young families, but it could also mean if I'm an employee and I'm caring for elderly parents, I have a family responsibility to look after my parent or parents in a particular way. It may mean I need some accommodation from my employer. Or it may mean if my spouse is sick, that I need to have an accommodation with respect to my hours, or can I work more from home for the period of time while I'm trying to care for the health of my spouse? It's really a revolutionary concept that's, as I said, gained lots of ground with respect to this. Well, I've spoken for about 25 minutes. I'm happy to to answer any questions that you have in the remaining 25 or so minutes from this. And as Haitham has said, please ask a question through the chat. I'm going to open up the chat function, and I can try to answer those questions that way. So, Haitham, can I ask you then to moderate the questions coming in?
Of course, sir. Well, if I may suggest, due to the number we have now, so it would be possible to if we can just let the people unmute themselves and ask ahead, because we don't have that big number, so that
Okay.
I think we can control the.
Yes.
What do you think?
I think that's fine. I think instead of getting people to write these out, if people wish to actually just unmute yourself and ask me the question. I see one question while we're waiting for that to happen. Yeah. I see that Jill has asked a question. Just let me read it out.
Of course.
Within the healthcare environment, are there requirements under legislation that articulate the responsibility of the organization for handling human rights complaints brought forward through a complaints management process? Well, that depends on the particular workplace, Jill. There are workplaces, some workplaces, particularly bigger and more sophisticated workplaces, often have very detailed human resource policies that include things like a formal policy on harassment to oppose it, a formal policy on managing human rights complaints, where they try to see if with some kind of informal or formal process internally, that may identify the issue to the employer. They may work to try to see if they can find a satisfactory resolution, and that would wind up working. So yes, I would think that any human resources system in a bigger and more sophisticated employer that has a kind of feedback coming from employees, they would be able to handle human rights issues or concerns, whether it's harassment, or it's a claim of discrimination on the basis of race, or it's a claim that I wasn't properly accommodated. That should be handled that can be handled internally. It's up to the employee themselves if they want to do it internally, or if they want to go directly to the Human Rights Tribunal. I see a second question answered here from Diana. Does a job candidate have to disclose? Sorry, someone has got.
Sorry. I'm gonna mute.
Okay, please. Yeah.
Yeah. Just a second.
Does a job candidate have to disclose a need for accommodation at the interview, or when is the best time to disclose this need? That's a wonderful question, and I get that all the time from my law students, and we always have a long and interesting discussion of this. Diana, let me just tell you a story. Is it
still? Oh. Yeah, I'm sorry.
Okay. I'm just wondering, it's Lama who, yes.
Yeah, well, yeah, everything is under control now.
Okay, so the short answer is this. If we're talking about human rights at employment, the Human Rights Code not only applies to the fact when you have a job and you need protection from discrimination at work, or you need an accommodation at work, it also applies at the hiring stage as well. And I'll tell you a story. There was a woman who was a Seventh-day Adventist who required, who got a job at a big pulp and paper mill in Northern Ontario. They were looking for lab technicians, and she had all the qualifications. And they had 5 lab technicians already. And what they wanted was to hire a 6th person, so that each lab technician, besides working on a Monday to Friday shift, one lab technician a week would work a Saturday shift as well. So the 6 lab technicians would each work 1 day a week, one Saturday until it was their time to work again. This woman was a Seventh-day Adventist. She could not work on Saturdays because of her faith. And said right on the job application, candidates must be able to work an occasional Saturday. So she did the job interview. She didn't indicate that she was a Seventh-day Adventist and therefore was looking for an accommodation, but she was worried that she wouldn't get the job. They hired her. So the first 3 months, she worked as a probationary employee only on Monday to Friday shifts, and the other 5 employees worked rotating on the Saturday shift. So towards the end of her 3 months, the employer came to her and they said, you know, you've worked out great. We want to hire you permanently. Here's your fall working schedule, and you'll see which Saturdays you have to work. And at that point, she said, well, I can't work Saturdays because I'm a Seventh-day Adventist. And they said, oh, darn, why didn't you tell us that? Well, she said, if I told you, I was frightened you wouldn't give me the job. So what she said, but I can work Sundays because Sunday is not is a holy day for me. And so at the end of the day, they fired her for not disclosing. And she took this to the Human Rights Tribunal, and she won her case. And essentially the ruling from that is that if you are entitled to raise the fact that you need an accommodation at the hiring stage, and your employer should accommodate you. But it's often very hard for an applicant who's refused a job when they've raised the need for an accommodation because they don't have any proof that they weren't hired for some other reason because there was an absolutely better candidate, or they weren't hired because the employer just didn't want to put the effort into making an accommodation. So if people don't disclose their need for an accommodation until after they're hired, that's, you know, the law condones that or accepts that because of the legitimate fear it recognizes that employees may not get a job and it may not wish to reveal the requirement for an accommodation during a job interview. So there's no more questions right now listed on the chat function, but if somebody wanted to unmute themselves and ask me a question, I'm certainly happy to do that.
Yeah, participants now can have the privilege of unmuting themselves. So please, guys, if you have any question, feel free to unmute yourself and ask ahead.
Mm-hmm. While I'm waiting for the next question, if there's none right now, or is there one? Sorry, I see some people unmuting themselves. Yes, Priti has raised her hand. That's probably the best thing to do is to use the raised hand function. Go ahead, please.
Sure. Yeah, thank you. Thank you, Michael. That was really helpful. I'm new to Canada myself, and I'm a human resource professional. So this was really helpful to understand where you're coming from.
Mm-hmm.
So my question is slightly around if I'm a candidate who is applying for a job, is it necessary to disclose the location where I'm? What are the legal things around disclosing of legal? Because I'm afraid sometimes if you're in a different region from where the organization is based out of, they might not take you on board. So in that sense, is there any legal obligation, number one? And two, as a candidate, what is it that I can expect?
Sure. So what you're asking is, if you're in London, if I understood you correctly, and please correct me if I didn't catch it,
sure.
Pretty, but if you're in London and you're applying for a job in Toronto, do I have to reveal in my job application or my covering letter that I'm living in London?
Exactly.
I don't think there's any need with respect to being able to do that. The only things that you have to be able to display is that you are competent for the position, that you have the kinds of qualifications that they're asking for. You know, they're looking to hire a lawyer. You've got to show you've got a law degree and you're called to the bar, as in one example. But to say you're applying for a job in Toronto and you live in London, I don't think that's not necessary to reveal. At least initially in your job application.
Right.
And you had a follow-up question.
Yeah, so if I haven't revealed and if I am given the offer, is there something as an obligation that as a candidate I'm supposed, and what if they're not hiring me for that purpose? So is that something that I have any rights again there as a candidate?
Sure, but what's interesting, and I've seen this as a labor arbitrator over the last 10 years, I can remember doing cases where I was the adjudicator, and and someone, because of, let's say, a bad back, they lived in Mississauga and their job was in Scarborough. They're saying, look, it's punishing on me to drive 40 minutes each way, each day.
Sure.
It's really bad. Can I work from home full time, or can I work from home 2 days a week? And employers were very stubborn about that. But of course, the world has changed. And the ability to be able to, to get a job in Toronto but stay in London, or get a job in Halifax and be in Vancouver. We've learned many things over the last almost 2 years. So employers would probably have a more difficult time saying that, some employers might have a legitimate reason to say, we need you here all the time, and they've got to be able to prove that, or we need you here 2 days a week with respect to that. But for most employers, right now there's a job shortage, and employers are looking for talent, and they recognize that employees have now developed different expectations of work over the last 20 months. So it all depends upon the type of work, but for increasingly, where most of us are knowledge workers, where we're working at a computer and we're working with our particular skills and talents, we're much more flexible. So employers are less likely to insist, I need you here 5 days a week, because they know that's going to discourage the kind of talent they're hoping to attract to work for them.
Sure. Great. Thank you so much.
You're welcome, Preeti. That was a very good question. Any other hands or any other questions from people?
I'll just ask.
One thing, while I'm waiting for the next question, one thing I'm sometimes asked about is age discrimination. And this is becoming increasingly prevalent as a grounds for discrimination complaints in the workplaces, where it's just the area I know the best. Think of the changes that have gone on. 35 years ago, in the early 1980s, the average age in Canada was around 28 years old. Today, it's the average age now of Canadians is around 42 years. We've become an older society. We have less children. We're in better health. We live longer. We live better. We're moving away from physical work to knowledge work and brain work. So the average age of when people want to retire is getting older and older. It had dipped as low as 62 years about 5 years ago. Now it's gone up to almost age 65. Keep in mind that about 14 years ago, Ontario did away, along with virtually every other jurisdiction in the country, they did away with mandatory retirement. Up until 2007, an employer was able to tell you, you have to leave at the age of 65, no matter if you want to keep on working. And I have the right to be able to end your employment. That no longer is the case with the amendments to the Human Rights Code 14 and 15 years ago, which now means that either out of love of work or out of need for money, people are working. There's increasingly people over the age of 65 are taking up a greater and greater percentage of the workforce, and are working often, even into their early 70s. And this has given rise to two interesting phenomena. One, obviously, many employers want to encourage people to either continue working for them because it's a knowledge skill, and they know that their older workers are healthier than ever before, are better trained than ever before, and probably more ambitious than ever before. But also, for some employers, there still remains the myth of what we call is ageism, that they're based on the assumptions that older people can't do the work, they're not technologically equipped or competent to do this kind of these kinds of activities, and they want to get rid of older employees, or they don't want to hire older employees. And the Human Rights Code protects people against age discrimination. Now, I should say this, that we have one of the most sophisticated human rights legal systems in the modern world, certainly when it comes to these kinds of standard prohibitions against discrimination. We've done very well with a wide definition on discrimination. We've done really well with family status. We've done really well with on expanding religious rights at work. We've done pretty well with respect to gender rights at work. The two areas where we haven't done so well, and we're beginning to learn how to do better, is there's been very few major cases on race discrimination at work that have been successful. And as well, there's been very few cases that there have been successful cases on age discrimination. However, the good news is, I think we're changing. I think we're getting to see, because there's been a much greater awareness on racial discrimination in Canada and the fact that we have systemic racism in Canada, particularly with respect to our Indigenous population and with respect to people of color, that adjudicators and the courts are becoming much more sensitive and much more open-minded with respect to accepting complaints on the basis of race and finding them that these cases have been made out. Same thing is slowly beginning to happen with respect to age discrimination as well, that we're beginning to recognize that there is this concept of ageism, that there is discrimination, widespread discrimination on the basis of age throughout our society. And if I can tell you something with respect to race, there have been several experiments done by university professors and their students who are learning about how to do sociology research in our society. And what they've done, they wanted to find out if employers would discriminate against people who had the identical qualifications for a job vacancy, depending on whether or not these qualifications came from abroad or Canadian, or if the job qualifications were equal with respect to Canadian skills and experience, but one person had an Anglo-Saxon name and another person had a name indicating that they were probably a person of color. And they sent these applications out. And they've done this in Toronto. They've done this in Montreal and Quebec City. They've done this in Vancouver over the last decade or so. There's been 3 or 4 of these major experiments. And every single time they've done this, with, as I said, they'd send out these dummy applications responding to job vacancies for a fairly sophisticated employer that have been advertised. And they would send 2 applications, one from somebody with foreign qualifications, but very good qualifications, and one coming from Canadian qualifications. And they found that 40%, it was 40% more likely, 40 to 60% more likely that the person with the Canadian qualifications would wind up getting an interview. And when it was identical Canadian qualifications and experience, but where the name, one name was obviously indicating somebody whose racial origins may have come from the global South, and the other person had an Anglo-Saxon European name. Again, much the same sort of statistics with respect to job applications, that the person with the Anglo-Saxon name was something in the range of 40 to 60% more likely to get a job interview than the other person. And I say this to you, obviously not to discourage you from considering applying for jobs, but that we have to be alive, that when the Chief Justice of Canada talks about discrimination in society, and the Prime Minister talks about systemic discrimination, and major national public institutions acknowledge systemic racism in Canada, we have to be alive to being able to identify it, to address it, to call it out, and to complain about it. Nothing ever changes unless someone is challenged. I often say to my students, no one ever changes their mind unless someone else challenges them. But old practices, particularly discriminatory and unfair practices in society, will never change in our society until they're called out, until there's human rights complaints, or until there's good journalism that winds up exposing these sorts of things. So I've talked. Are there any questions on anything that I've raised or anything that has to do with human rights?
I do. I have one.
Diana.
Yeah, you hear me?
Yes, I can hear you.
I was typing, but it was going to take too long. So with the new news that came out from the Ontario government, where they're going to try to not require immigrants to have Canadian experience, etc. How do you think that this discrimination, how do you think that's going to play out? Because it's going to take a long time, I think, for really those.
That's a very good point. There are a number of things that organizations are doing, including governments, in trying to change or to improve their human resources practices. And one of them is to not put on someone's name when they're applying for a job, or not to put on where they got their experience. If they have a degree, they don't have to list where the degree comes from, i.e. is it a foreign degree or is it a Canadian degree? They're also saying you don't have to put your age on there as well. So these are all, I think, positive steps towards dampening, the very strong likelihood of discrimination in the vetting process when a human resources manager may be going through applications. We all know of the term inherent bias that come out of these systems. We all have probably our own inherent biases. The trick in life is to try to ensure that these are reduced and limited to the absolute degree possible. So if we're going to be a nation of immigrants, if we're going to try to welcome 400,000 new immigrants coming to Canada every year, we have to find ways of I think Canada is generally a very welcoming country, but we have to find more ways of making sure that it's even more welcoming, that the kind of barriers that exist in society aren't there. For someone who, white male, I would rarely ever see those sorts of things. And it always is a surprise. It shouldn't be a surprise, but it always comes as a surprise to me when people, particularly people of color, I've got lots of students who come from a variety and a diversity of backgrounds in my law classes, who talk about experiences they've had or experiences their families have had, and particularly in the work world, where there were unthoughtful things said, or sometimes unthoughtful acts that occurred that told the people, well, we're not entirely welcomed here in this society. If we're going to try to make sure we attract good people to come to Canada and we hold on to them to come to Canada, then we have to make sure that we expand and deepen not only our coverage of the Human Rights Code, but we expand human rights practices, particularly in employment. And I'll just say this last thing and invite any other questions. The workplace is a really interesting paradox with respect to human rights. If you go to any country in the world and you want to figure out, as perhaps a sociology experiment, who are the groups that are at the top of the society, who are the groups that are in the middle or the bottom of that society, and who are the groups that are marginalized altogether, the best place to start is always going to be the workplace. And you can see who's hired, who works in good jobs, who works in poor jobs, and who's excluded from the workplace altogether. So in many ways, the patterns of discrimination in any society are most visible in that country's workplace. But the other side of that is this. Over and over again, we've shown over the last 60 years in a number of countries that the best place to tackle discrimination in society is in the workplace, by having strong unions, by having very strong laws that protect against discrimination, by ensuring that workplaces are increasingly diverse and are welcoming not only to women, particularly in non-traditional jobs for women, but are welcoming to people of all sorts of abilities, of all sorts of diverse backgrounds. That the more we wind up focusing on the workplace as a means to dampen down discrimination and expand opportunity in society, the more we're ensuring that human rights values are going to prevail in society itself. Priti, I see your hand up for one more question. It's about 3 minutes too, so if you'd like to ask your question, I'll try to give a quick answer and then we'll turn it back to Haitham.
Yeah, thank you so much, Michael, for taking. I think it's very interesting what you're saying, but I'm just, curious to know as a newcomer about the diversity that you're talking about. Is there a law that exists again to maintain some kind of diversity and inclusion in every organization in Canada?
No, unfortunately not. The only jurisdiction in the country that has what we call an Employment Equity Act is the federal government for the federally regulated workplace. The federally regulated workplace would be companies like airplanes or railways or nuclear power or the federal public service or broadcasting or banks. On Ontario, we had an Employment Equity Act for about 2.5 years in the early 1990s, and then it was done away with by the Mike Harris Conservative government. So that doesn't exist. Companies are encouraged by governments to try to ensure they have a more diverse workforce. If you talk to the Human Rights Commission, they say that, you know, if you're not paying attention to issues of diversity, you're losing out on a lot of talent in this society. But alas, there is no formal rule or legislation which says that a company should have a certain level of diversity in their society, in their workplace.
Sure, that's very helpful. Thank you so much.
Okay, thank you for your questions, Priti. Haitham, if I can turn it back to you, as I think we're now back at the bewitching hour.
Yes, actually, thank you very much, Michael, for that very nice and useful information. It's, of course, something like the human rights codes in Ontario could not be covered in 1 hour at any way, but that was a very nice general idea that you gave us about it, and thank you for taking those questions. So if there is no more questions, I would like to thank our host for, actually, I see something from Haifa. Can we take it quickly, Michael?
Sure. Yep.
Yeah.
If anybody who may have to leave, you'll notice in the chat box that Haitham has said, please fill out the feedback form. He would appreciate, and I would appreciate, if you would fill out the feedback form, because it tells him and it tells me what worked and what didn't work in this presentation. So it'd be a great favor you're doing to us at Rights and Responsibility by filling out this, just taking a few minutes to fill out the feedback form. Haifa, you've asked, what if the human resources employee, the human rights employee was racist? Who do you complain to? Well, that sometimes happens in the workplace. You know, it's not the employer who is acting in a discriminatory fashion. Sometimes it's another employee working beside you. And that is equally against human rights legislation. If suppose another employee made a crude racist remark about you or in your presence about somebody else, or was harassing you either personally or based on sexuality, your first responsibility then is to go to the employer to file a complaint, to explain what just happened to you. And if the employer does therefore do a diligent investigation and finds that, you know, the other employee breached human rights provisions and took decisive action against that person, well, then the employer has done what's supposed to do under the Human Rights Code. But if another employee makes a racist comment towards you or in your presence, you go to the employer, you complain, and the employer does little or nothing. It does an inadequate investigation and provides an unsatisfactory response. Then you would have the choice of going to the Human Rights Tribunal to complain about the inadequate response. You're not complaining against the employee who committed the discriminatory action. You're also complaining against the employer for not protecting you. I should have said this at the beginning. Employers have an absolute duty to ensure that their workplaces are discrimination-free. That is their legal obligation. That is their lawful responsibility in this. And if they're not living up to that, then employees are able to complain about their employers, not only a direct racist comment by an employer, but if they are inadequate in their response to racism by other employees. So I'll leave you with that thought. And I want to thank Haitham again for inviting me. I want to thank Rights and Responsibility. This is a great service that Rights and Responsibility is organizing for the community. And I'm really happy to be a part of this. So
thank you. Michael, we've got just one final comment. Can you suggest some resources that for legislations that the newcomers could have to educate the newcomers about human rights?
Yeah, that's a great comment. Yes, and that's a great question to ask me. The best single resource, I think, is going to the website of the Ontario Human Rights Commission. And they have all kinds of explanations with respect to examples of racism, examples of discrimination, what the Human Rights Code is designed to protect, what the complaint process is. You'll find a wealth of information as a good starting point at the website of the Human Rights Commission of Ontario.
Thank you very much, Michael, and thank you everyone for joining us today. It was a great session, and looking forward to see you at another sessions for Rights and Responsibilities Awareness Initiative. Stay warm, stay safe, and be well, everyone.
Take care, everybody.
Thank you. Take care. Bye-bye.